Now the second quarter of 2024, Polity section, Article 31C, Article 39B of the Constitution and private properties. The news is Supreme Court is deciding on the question whether private properties can be seen as community resources under 39B. Supreme Court is also reviewing the validity of Article 31C after Minerva Mills case. Now about Article 39B, it obligates the states to develop policies that ensure the ownership and control of community resources are distributed to best serve the common good. Now about Article 31C, Article 31C was added to the Constitution through 25th Amendment Act of 1971. Article 31C states that law passed to implement the objectives of 39B and C cannot be challenged for violating fundamental rights under Article 14 and 19. Now a timeline of 25th Amendment and evolution of Article 31C. In 1970, the Supreme Court in the bank nationalization case, Cooper versus Union of India 1970, ruled against government acquisition of private banks due to inadequate compensation. In 1971, the 25th Amendment Act of 1971 enacted to reserve the Supreme Court's ruling in bank nationalization case. It added Article 31C protecting laws implementing Article 39B and C from courts challenges based on Article 14 and 19. In 1973, in Keshwanand Bharati versus State of Kerala, 1973, Supreme Court upheld the validity of 24th Constitution Amendment Act and Article 31C. The court struck down a portion of Article 31C that prevented judicial review of laws aimed at implementing DPSPs. The 42nd Amendment Act of 1976 expanded the scope of 31C to cover all DPSP outlined in Part 4 of the Constitution. In 1970, in the Minerva Mills case, Supreme Court ruled that provisions of 42nd Amendment Act, which enlarged the scope of Article 31C to include all DPSPs and shielded it from judicial review, as unconstitutional. Now, rights against climate change as fundamental right. The Supreme Court in its latest judgment has recognized the right against adverse effects of climate change as distinct fundamental right in the Constitution. Now, about the Supreme Court's ruling in M.K. Ranjit Singh versus Union of India, also known as Great Indian Bustard Case 2021, the Supreme Court stated that the right to protection from climate change is linked to right to life under Article 21 and the right to equality under Article 14 in the Indian Constitution. Now, constitutional provisions on climate change. Article 48A requires the state to protect and improve the environment and safeguard the country's forest and wildlife. Article 51AG requires Indian citizens to protect and improve the natural environment and show compassion for all living beings. Article 21 recognizes the right to life and personal liberty, while Article 14 ensures the right equality before law and equal protection of law. Now, the court also emphasized that right under Article 21 and Article 14 cannot be fully enjoyed without a clean and stable environment. In 2000 case of MC Mehta versus Kamal Nath, the Supreme Court declared that right to clean environment is an extension of the right to life under Article 21. Now, Supreme Court on misleading advertisement. The Supreme Court urged the government to address the misleading advertisement by FMCG, that is fast moving consumer goods firms. Now, about misleading advertisements. Misleading advertisements refers to any claim made in publications that creates a false impression of a product or service for the consumer. Now, legal provisions to counter misleading advertisements. The Drug and Other Magical Remedies Act of 1954 prohibits misleading ads in medicine with penalties up to 6 months in jail or a fine and harsher penalties for repeat offences. Under the Consumer Protection Act of 2019, misleading ads can lead up to 2 years in prison and fine up to 10 lakh rupees. Repeat offences may result in up to 5 years imprisonment and a higher fine. Food Safety and Standards Act of 2006, penalties for misleading food advertisement. Guidelines for prevention of misleading advertisements and endorsements for misleading advertisements 2002, issued by Central Consumer Protection Authority CCPA. Now, curative petition. The Supreme Court recently set aside the 2017 arbitral award in the Delhi Metro Reliance infrastructure dispute. This has raised questions about the use of curative petition in a commercial case. Now, about the curative petition, it is the final option to seek relief from the Supreme Court. Curative petition can be filed after a review plea against the final conviction is dismissed. The decision of the Supreme Court is final in this regard. curative petition is not an appeal. The aim of curative petition is to prevent miscarriage of justice and discourage abuse of the legal process. The principles governing the curative petitions were established by the Supreme Court in the Rupa Ashok Hura versus Ashok Hura and another case, 2002. Now, constitutional support, Article 137 of the Indian Constitution broadly endorses the concept of curative petition. Criteria for admission: it can be considered if the petitioner proves that the principle of natural justice has been violated. It can be admitted when a judge has failed to disclose facts that raise the apprehension of bias. Now, guidelines for filing a curative petition. A curative petition requires certification from a senior advocate listing several valid reasons for consideration. The petition is first reviewed by a bench of 3 senior-most judges along with judge who gave the original judgment if available. If majority of judges find the hearing necessary, it is scheduled, ideally before the same bench that issued the original judgment. Now, Ladakh demands for the inclusion of into the 6th schedule. The people of Ladakh were protesting for the inclusion of Ladakh under the 6th schedule. About 6th schedule, Article 244, Clause 2 of the Indian Constitution provides for 6th schedule that applies to administration of tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. The 6th schedule provides for the establishment of autonomous district council ADCs or regional autonomous councils to govern these areas. Now, key features: autonomous district and autonomous regions. The governor is empowered to organize and reorganize the autonomous district. He can also increase, decrease the boundaries or alter the name of any autonomous district. If an autonomous district is inhabited by different scheduled tribes, the governor can divide the district into separate autonomous regions. Autonomous district councils and autonomous regional councils. Compensation of ADCs. ADCs consist of not more than 30 members, with 4 nominated by the governor and the rest elected. The Bodoland Territorial Council is an exception, allowing up to 46 members. ARCs, a separate regional council can be established for each area designated as an autonomous region. Now, the powers of ADCs and autonomous regional councils, ARCs, oversee land use, inheritance laws, social customs. They possess legislative, executive and financial powers, including the authority to collect taxes and manage local resources. Exemptions and modifications. Act of Parliaments or state legislatures may not apply directly or may apply with modifications. Allocation of election symbols. There has been a controversy in Maharashtra about the allocation of similar symbols to a political party and an independent candidate in general election of 2024. The Election Commission of India manages the allocation of symbols in the elections. The Election Symbols Reservation and Allotment Order 1968 governs the reservation and allocation of symbols to recognized political parties. Symbols are classified as either reserved, that is reserved solely for recognized parties, or free, that is accessible to unrecognized registered parties. Recognized and registered national and state parties get exclusive symbols. Unrecognized registered parties can select from free and non-exclusive symbols. Now note, Rule 10b of Symbols Order states that a registered unrecognized party can use a common free symbol for 2 general elections. Unrecognized and unregistered parties must choose 10 symbols from Commission's list and can suggest 3 new symbols with design and names for approval. The ECI may assign a proposed symbol as a common symbol if found suitable. In case of a split of a recognized political party, the Election Commission determines the allocation of symbols. The Chief Election Commission and other Election Commission Appointment, Condition of Service and Term of Office Act 2023. The President appointed Election Commissioner to fill 2 vacancies under the new appointment law. Constitutional provisions for appointment of EC. Election Commissioners appointed under Article 324 of the Indian Constitution, which grants Election Commission of India the authority to supervise and control elections. Now, key features of the new Act. Appointment. The President appoints the CEC and EC based on recommendations from a selection committee which includes the Prime Minister, a Union Minister and a Leader of Opposition. A search committee led by the Law Minister proposes a list of candidates to the selection committee. The qualification of CEC and ECs. Persons who are holding or have held posts equivalent to the rank of Secretary to the central government will be eligible to be appointed as CEC and ECs. Such people have the expertise in managing and conducting elections. Now, the salary. The bill provides that salary, allowances and service condition of CEC and ECs will be the same as that of Cabinet Secretary. Now, home voting facility. The Election Commission of India has introduced a voting facility for the 2024 Lok Sabha elections. Procedure to avail the facility: eligible voters must submit Form 12D to the Assistant Returning Officer, that is ARO, stating their inability to visit a polling station. Now, eligible persons are people aged 85 and above, service voters, that is armed forces, CAPF, and poll duty personnel, persons with 40% plus certified disability, essential workers, that is metro, railway, healthcare, etc., media persons with EC authorizations. These are the eligible persons. Now, additional initiatives by ECI for accessible voting, implementing systemic voter education and electoral participation, that is SWEEP, to engage and educate PWDs, their families, and officials. Introducing remote electronic voting machines, that is RVM, to allow migrant voters to vote from their current location. Power of Enforcement Directorate adjudicating authority under PMLA. The Supreme Court recently upheld the Enforcement Directorate's broad powers under the Prevention of Money Laundering Act 2022. About PMLA was enacted to prevent money laundering and confiscating property from illegal activities like drug trafficking, smuggling, and terrorism financing. The PMLA was enacted by the Parliament under Article 253 to fulfill India's obligation under international treaties and conventions like United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances and FATF recommendations. Now, key powers of ED. Proving financial crimes. The ED investigates money laundering and economic offences. Freezing and seizing assets. The EC can freeze and seize assets linked to illicit activities. Property attachment. The ED can attach properties tied to money laundering for 180 days, extendable by adjudicating authority. Issuing summons under Section 50, Subclause 2 of PMLA. The ED can summon individuals to provide evidence or records. Section 53, summoned persons must appear and provide truthful statements and documents. Arrest. The ED can arrest individuals for money laundering or foreign exchange violations with or without a warrant. Now, about ED. ED in the Department of Revenue, Ministry of Finance, is responsible for investigating the offences of money laundering and attachment of properties. Now, about the adjudicating authority under PMLA. The PMLA provides for the establishment of an adjudicating authority to exercise the jurisdiction, power, and authority granted under the Act. Under the PMLA, the adjudicating authority decides within 180 days whether the properties attached by ED are linked to money laundering. Section 5 allows for the seizure of property suspected to be acquired from proceeds of crime listed on the law schedule. Attachment orders are issued when the ED director suspects the proceeds may be concealed or moved. The provisional attachment lasts for 180 days. It must be confirmed by an adjudicating authority appointed by the central government within this period, otherwise the property is automatically released. Right to appeal. The accused has the right to challenge the adjudicating authority's confirmation order at PMLA's appellate tribunal within 45 days. National Human Rights Commission. The Geneva-based Global Alliance for National Human Rights Institutions, GHANARI, has deferred accreditation for the National Human Rights Commission, NHRC India, for the second consecutive years. NHRC is a statutory body established under the Protection of Human Rights Act of 1993 in conformity with the Paris Principles of 1991. The Commission serves as the guardian of human rights in the country. The composition. The Commission is a multi-member body with chairman and 5 members, excluding ex-officio members. Chairperson is a retired Chief Justice of India or a Supreme Court judge. Now, members: 1 member who is or has been a judge of Supreme Court, 1 member who is or has been the Chief Justice of a High Court, 3 members appointed from individuals with knowledge or of practical experience in human rights matter. Note: at least one of the 3 members must be a woman. Ex officio members: chairpersons of national commissions, which is National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Women, National Commission for Minorities, National Commission for Backward Classes, National Commission for Protection of Child Rights, and the Chief Commissioner for Persons with Disabilities. Now, appointment. the chief chairperson and members are appointed by president based on recommendation from a 6-member committee, which includes the prime minister, head, speaker of the Lok Sabha, deputy chairman of the Rajya Sabha, leader of opposition in both houses, the central home minister. Now, tenure. The chairperson and the members serve a term of 3 years or until age 70, whichever comes first, and are eligible for reappointment. The NHRC has the power of a Supreme Civil Court under the Code of Civil Procedure under 1908 about Global Alliance for National Human Rights Institution, GHANARI. It is a global network of national human rights institutions that work to promote and protect human rights. It has 120 members around the world. India is also a member. Subcommittee on Accreditation evaluates national human rights institutions every 5 years, and there is an appeal process in place to promote transparency and due process. Now, to the point, World Press Freedom Index 2004. It is published by Reporters Without Borders. India has been ranked 159 out of 180 countries. Scandinavian countries, that is Norway, Denmark, Sweden, tops the ranking. In South Asia, India ranks lower than all countries except Bangladesh. Internet shutdown in India 2023 Access Now report. India has the highest number of internet shutdowns globally for the 6th year in a row. In 2023, the number of internet shutdowns worldwide grew 41%, reaching 283 from 201 in 2022. Provisions for internet shutdown, telecom service suspensions, including internet shutdowns, are currently governed by Temporary Suspension of Telecom Services Rule 2017 under the Indian Telegraph Act 1885. It allows for a temporary telecom shutdown in a region for up to 15 days due to public emergency. Temporary telecom suspension orders can be issued by the Union or State Home Secretary. Now, terms and news. Preventive detention. Preventive detention involves holding someone without trial to prevent future crimes rather than punishing past actions. Detentions cannot exceed 3 months unless an advisory board approves an extension. Constitutional provisions. Article 22 grants protections to persons who are arrested or detained. Original jurisdiction of Supreme Court. Article 131 of the Indian Constitution grants Supreme Court original jurisdiction in specific dispute cases, disputes regarding the center and one or more states, between the center or any or states on one side and one or more states on the other sides, between two or more states. These are the original jurisdiction of the Supreme Court. Now, Form 17C, the Conduct of Election Rules 1961 mandates the Election Commission to maintain 2 forms, that is Form 17A and Form 17C. Form 17A captures the detail of each voter who enters a polling booth and votes, while Form 17C records the total number of votes cast. EVM and VVPAT. EVM stands for Electronic Voting Machine. It is a device used to electronically record and count votes cast in the election. It is manufactured and supplied to the ECI by Bharat Electronics Limited under the Ministry of Defence and Electronic Corporation of India Limited under the Department of Atomic Energy. EVM consists of 3 units. Ballot unit, which functions like a keyboard using which the voters cast their votes. Control unit, it controls the operation of the ballot unit and manages the data. It remains with the presiding officer or a polling officer. VVPAT, that is voter verifiable paper audit trail, allows the voters to verify that their votes are cast as intended. When a vote is cast, a slip is printed containing the serial number, name and symbol of the candidate and remains exposed through a transparent window for 7 seconds. Star campaigners during elections. A star campaigner is a celebrity vote seeker for a political party under the Representation of People Act 1951. Star campaigners must be a party member. The term is not defined in the Act but is commonly used. Under the RPA 1951, a recognized political party, national or state, can appoint up to 40 star campaigners, while a registered unrecognized party can appoint up to 20. Travel expenses for star campaigners during general election party campaigning don't count towards the candidate's election expenditure limit. However, if they campaign for a specified candidate or share platforms with them, the expenses are counted as part of the candidate's expenditure. Article 329B. Article 329B is part of Part 15 of the Indian Constitution, which specifically addresses electoral issues. Article 329A restricts the judiciary from questioning the constitutionality of laws concerning electoral districts, boundaries, or seat allocations. Article 329B, as amended by the Constitution 19 Amendment Act of 1966, states that elections to either House of the Parliament or state legislature can only be challenged through an election petition as outlined by the law. Legal framework for election petition. The Representation of People's Act 1951 specifies that high courts are the authorities empowered to hear and decide election petitions. Decisions from these petitions can be appealed to the Supreme Court. That'll be all for this video. We'll be starting with international relations in the next video.